Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
I like it. It allows the parents to hopefully have that peace of mind to where, okay, my child is here. I was told they were going to be here and I feel better. But as the child gets older, I think you even have more peace of mind as they get into those teen years to where they're maybe saying they're going to one place, but end up in another place. And iPhones have tracking devices too. And they're really, I was just talking to a colleague of mine and she has this interesting case to where the child kept sneaking out of mom's house. But mom kept saying, "Oh no, that never happens here." But yet they have it on the iPhone of saying, "Oh well, wait a second. I see it's 2 a.m. and there goes the child, and the child is going to see her boyfriend." And mom is either oblivious, doesn't care, whatever the case may be. So now you have these concerns of, well, what really is happening at mom's house, and is it in the best interest of the child to be there? And so tracking devices will continue to play a wonderful tool in helping courts really navigate kind of that he said, she said.
I guess I kind of take the fear of at some point the court's pushing back and saying you're surveilling the other parent's time, right? You're purposely surveilling the other parent's time. Yes, the other parent was 5 minutes late picking up from school, and it's none of your business. So I do think that we need to be careful in our use of the information, right? So we're not nitpicking certain little things. We're saying, look, like Dan said, the child snuck out of the house every morning at 2 a.m. to go see their boyfriend, and mom's saying that never happened. Well, we can use this as rebuttal to what mom said, or like Rebecca said, the child's always picked up late from school on the other parent's watch. And they're like, no. And we say, look, here's the tracking record to show every day, 30 minutes late they're getting to school.
Mm-hmm.
But I do have concerns that judges will push back to begin with and say, look, you can't surveil the other parent's time. So, flipping the coin now, and I'll throw this to you, Rebecca. What do you tell a client who is withholding the child from the other parent?
Right. So again, you want to find out the reason. Is there some sort of history of abuse? Is there some sort of health issue with the child? I previously had a case where mom had a very young child who had some really severe lung issues. And dad was a smoker, and dad lived with his mom, who was also a smoker. And every time the child would go spend any amount of time with dad, he would come back and have this lung issue. He would have to, go on inhalers. He would have to sometimes be hospitalized because his oxygen would get too low. It was pretty severe. And in spite of her repeated attempts, dad was just still living in this smoke-filled home, and not doing anything to accommodate the child and the child's needs. And so in that situation, it was a safety risk, right? It was a concern for neglect. It was a concern for harm to the child. And in that situation, you want to document the reason, right? So we can pull the health records and show child went to dad's house on this day, child had to be hospitalized the following day and had, all these other issues as a result. We also got a guardian ad litem involved who went to dad's house and was able to say, yeah, the walls are covered in smoke. This has been a smoked in residence for the past 20, 30 years, something like that. And so we were able to put the pieces together where we could explain to the judge, Your Honor, this is the reason for it. This wasn't just her being malicious. This wasn't just her wanting to withhold the child. This was child cannot spend time at dad's house without a health risk or a health concern. And I advised her that we can meet at public places, right? You can go meet him at the park. They can spend time at the playground. They can maybe go out to eat or, something like that. So that, again, we're not 100% denying access to the child. We can still do FaceTime calls. We can still do other things. So again, we're showing the judge that you're acting in good faith. But there is this safety and this health concern over here. If you have someone that doesn't have a basis for it, though, again, they're going to get that same advice because this is going to be used against you. And it's going to be really hard for me to represent you and advocate for you if you're just completely denying access to the other side. This is going to come back to bite you. So if you don't have a reason for it, we need to figure something out, something that's going to be possible, for you guys to meet somewhere, for you to do the FaceTime calls, for them to have some amount of visitation. Sometimes the other parent's living situation isn't great, like they live in a group house or something. You know what I mean? Like, but you can work around that. That's still not going to be an excuse to completely cut off the other parent. And if the client still continues to do it, we're going to be really limited in in what we can do for you at that point, unfortunately.
We kind of brought up an interesting thing with the smoker's house, that there was a filing made. So when your clients started withholding the child for what seems like it was a good reason, how long did you wait before you filed something with the court to get ahead of an opposition filing?
Right. So I believe in that case, both parties had already started petitions, but dad was filing everything he could possibly figure out to file emergency motions, claiming this, claiming that. He was trying to file show causes. He was really trying to go after it. And so at this stage, like kind of looking back, if I were starting from square one with that client, I would say we need to file a petition right away. And we maybe need to attach a motion about temporary visitation and include some of these details. On this date, this happened and the child had a health problem. And so for that reason, we're asking the court not to allow visitation at dad's house, but we can allow visitation in other, some sort of other circumstance. And I would say that's how you maybe get ahead of it, where the judge is at least reading that hopefully first, and getting an idea that this isn't just malicious.
And Dan, I'll ask you the same question. What do you do when a client comes to you and says, "Look, I am not turning over my child to the other parent"?
You have to dig in. As lawyers, we ask questions, right? Just is innate in us, and so we need to figure out what is going on. Because if there is a good faith basis for the denial, then we can reach out to the other side if they're represented. It's always better to talk with another attorney, but if not, then try to reach out to see if we can't come to some type of amicable resolution. But if we can't, then we have to file with the court, especially if there's no filing currently in place. But it all starts with what is the reasoning why, because it has to be a good faith basis. And if it's not, then it's discussions on, well, what's going on that you really want to deny the time. And I have had cases where the other side now has a girlfriend or a boyfriend, and unfortunately that's just life, right? And they just like, there's no way, I don't want them to be around them. Well, the court could care less. At least I'll press it where I practice in the states I'm licensed. Judges don't care if someone else gets remarried or has significant others. It's what is going to be that effect on the child. And if there's no effect, and there's nothing that can be done. But if you do have some concern, then just kind of start talking to the parent and be open about it. I have some concern that you're seeing someone new. Is this an appropriate time to introduce our child to them? And then just make sure you have those frequent, meaningful contacts with the other side, and then document it. And then if the child comes back and has some concern with the other parent's significant other, then you can take it to the next level. But if it's just because you woke up one day and like, you know what, I don't want my child to see the other side, that's not going to fly. And we have to advise the client, you can't do this. And if you continue to do this, then here's are the remedies that could be available to the other side. And you could jeopardize your time. You could compromise that and put it in writing so they see it. It's not just a CYA from a practice side. It's, individuals, including myself, like this. I'm visual, so you can tell me something. I may or may not hear it, or may not resonate. But if I see it, then there's something else that I can go back to and reference to. Or as lawyers, we can say, go back to I outline what could happen if you do this. This is something that you really want to do. And then if they still move forward with it, then we need to kind of flip on how we're going to represent them. And it's not that we're going to agree with what they did, but it's okay. What can we do to mitigate what just happened so you don't have remedies taken against you? But it all starts with, at least when I meet with clients, to determine what is the reasoning why, and go from there.
And when you're talking to your clients, Dan, and you're digging in, and let's say you find something where the other child is in danger at the other parent's house, how do you handle that?
It depends on what that danger is, because I mean, you got a whole range of things, right? From what Rebecca was saying to olive to abuse, or even some type of inappropriate activity, right? Whether it's drugs, sex, whatever. So find out what that is, and then how does that affect the child? And if it does fall into one of those categories, then if they're represented, then I would contact the other side and say, we're not going to allow representation at that particular place because of whatever the reasons are. But if it's abused by the other side, then we want to let the parent know or the attorney know we're not going to allow this. And we may have to get in front of a judge because we have concerns that the child's safety is going to be compromised or jeopardized. And until that other side can get help, this is what we propose. And it could be a denial of time until that side seeks the appropriate help, or it could even be supervised just till that other side gets back on track. But I found in my experience, if we can offer not just solutions, but offer ways to be able to try to encourage that communication and visitation, that goes a lot further with the judge. But there are going to be those times that we've talked about to where it is in the best interest of the child that they just do not see that parent. And until that parent can seek whatever help it is that he or she needs.
So, and I'll stick on this idea with you, Dan. When you have this situation which is causing harm to the child, let's say there is something causing physical harm to the child, how does it play with the court when the other parent allows visitation to continue to happen a little bit and then says, you know what, this
Yeah.
harm has gone too far?
You come across that, and unfortunately that does hurt the case because it's hard to argue both sides. You can't say, well, I fear for the life safety of my child because of XYZ, but oh, I'm going to let mom or dad see the kid. Oh, now I'm afraid. So it's either you are afraid and you don't want the child to see them, or you're not and the child can see them, because you're making the case for the other side. Because if I'm representing the parents being denied time, I'm going to say, well, wait a second, you didn't care on this day, you didn't care on this, but you carried on here. So it doesn't make any sense. And that frustrates the courts because then you're wasting judicial time when there's so many other issues that the courts can be involved in and help out with, to where in this situation you got one parent playing a game with the other. And it really, at the end of the day, it hurts their credibility of their case, but also hurts the credibility of that parent and the veracity of that parent. It may not just be for the current case, but if there's any issues down the road, the court's always going to remember, well, what happened here. And it's the same thing when you have orders of protection. It's you can't say I fear for my life and safety. I go and file that because that's the appropriate thing to do on what we've been talking about. But then if you let the other parent see that child, or you communicate with the other parent, then it doesn't make any sense.
Yeah, exactly. And I had a case one time where the other parent had driven drunk with the children in the car, got pulled over, got the DUI, got the children. We went and filed in our jurisdiction what's called an emergency motion, and won. The court was very aghast at the fact that a DUI had happened with the children in the car seats in the back. Very easy case. It wasn't, not a lot of tact on my part. Very easy case. So Rebecca, in emergency motion situations, what do you advise clients to do, and how fast do you advise clients to move?
Yeah, so if you're checking any of those boxes, right? Abuse, harm, neglect, risk, something along those lines. You want to make sure you're filing something right away. And a lot of jurisdictions will push back on you when you show up at the courthouse window and you say, I want to go see a judge today or maybe tomorrow. They're going to say, yeah, we don't do that. And so it's really going to take having a skilled practitioner who knows that court and knows their systems to be able to get you what you need. We've had a number of clients call us and say, I've tried, I've gone to the court and I've said, I need to do this. And the clerks are like, I don't know what you're talking about. But you really do need to take action right away. So you not only need to file your motion, you need to try to notify the other side about the motion, because you can't have a hearing unless the other side is put on notice. And so that's something that, again, you have to arrange really, really quickly to make sure they get served today so that you can have your hearing tomorrow. One of the worst effects is if you're filing, the judge says yes, you go in front of the judge the next day and they say, where's the other side? Did you give them any notice of this? Oh yeah, okay, well, we can't do this hearing now. But you really do need to act as quickly as physically possible, because you don't want, obviously, any more harm to happen to the child. And you also don't want there to be some sort of delay in getting into the courthouse. And most of the time, it's going to take at least a couple of days before you can get in front of a judge. And so if you have something really, really urgent, that can't come soon enough. If there's something else, though, that maybe the police can intervene with, you may also make a call to them. The courts can only act so fast. The police can go a little bit more quickly sometimes.
Yeah, and Dan brought up a wonderful idea too. The protective order of protection. You
Mhm.
can seek an order of protection, a protective order on behalf of the child. In a situation where the court sometimes just can't move fast enough. If something happens at 4:30 on Friday, an order of protection, they can go get that from the magistrate and start making moves with the police and everything like that.
Mhm.
Uh, Dan, how do you handle situations where you and your client talk and you see something that's very bad, like a heightened level of corporal punishment? And then you get in front of a judge that just looks at even videos and marks and bruises and gashes and everything else that you can imagine that's bad. And the judge goes, well, that looks like normal punishment to me. How do you handle that?
Well, fortunately, it hasn't happened too often, but in the situations where it did, it was more of the. Actually, I've been on both sides. I've been on one side where the judge, said, "Yeah, I don't believe in spanking my kids," and just a tap on the butt was child abuse. But there was no bruises, no marks, nothing that you described, and so my client was going to be punished. But fortunately, we were able to take that up on a writ because it was in the middle of a case. But if you're in front of a judge who and you have that evidence that you described, usually if you're dealing with something so sensitive like as far as abuse or any type of inappropriate activity, I always want to see if I can seal the file first, because you don't want it to be a matter of public record and have anyone be able to potentially have access to that. And then another remedy is in camera review. I'm always a big proponent if the judge is hearing cases from the bench and you have other attorneys there, to be able to go back in chambers and discuss, especially if it's something that's so sensitive that you just want the judge to be able to weigh in without outside influence as far as having others hear it. And then talk to the judge and let the judge know, we have some evidence that could be damaging or harmful, but it's also very sensitive to the child. And here's, if it's my client's the one that is being accused of it, then I usually try to be a little bit more proactive and have a guardian ad litem appointed to the case so we can get ahead of the game and figure out, okay, what happened, what led to that, if there really was those types of issues going on, and then if there was, to have those hard discussions with the client, because you have to be able to advocate for them. Even if your client's in the wrong, you don't just give up. It's okay, do we need to go to anger management courses? Do you need to seek professional help of some type? Let's get you in that, because in the interim, you may not see your child. But if we can show that you own what you did, you know what was wrong, you're taking the steps to try to help yourself, then that will go a lot further in the court system, because we may have to start slow and go from limited time with supervised visitation to more time to unsupervised, and hopefully back to where it was. But if I'm on the other side, then I take a little bit more aggressive approach in saying, listen, judge, this cannot happen. And if the other side hasn't taken any of those remedial steps, I like to point that out to say, judge, regardless of what the situation is, there's harm to the child, so we need to remove the child. The court is under a duty to appoint a guardian ad litem, at least where I'm licensed. If there is harm to the child, then the court has to appoint a guardian ad litem, and then let the advocate for the child to be with that parent until further order of the court. And that might be even just permanently modifying, and then let the burden shift to the other side to down the road come in and file a motion to modify.
Yeah, I think what you said there was very important. When you're talking about working with an attorney that's truly your partner through this process, they need to be able to be open with you and say, "Look, you're in the wrong. We know that. Now let's take steps to see what we can do to fix this." And I know as a practitioner, I've walked into court so many times and looked at the other side, saying, "Man, if your attorney had just advised you to go to anger management or some sort of parenting
Mm-hmm.
classes, I wouldn't be able to do what I'm doing today." And I've got to advocate zealously for my client, but we can still see it from the other side and say, well, if you had done anything to mitigate what had happened here, if anybody had been honest with you, and that's what's so important when you're looking for an attorney and you're working with the right advocate for you, they are going to be a partner. They are going to tell you the truth. So, if you or someone is going through divorce and you're truly looking for somebody that's going to be honest with you and your partner, give us a call. It's these conversations like this that sometimes get difficult, but they are very good to hear. Look, hey, I'm not always in the right. And if I'm not in the right, you're going to tell me how to get in the right, or you're going to tell me how to fix it. Or, hey, the other side is very wrong, but you're going to tell me what to expect when I call the police. So if you or someone you know could really benefit from this information, please pass it along, click like and follow us. And we look forward to joining you next time.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.